requirement into Article 149(1), where none appears in the text, would be to engage in precisely the kind of unbridled extrapolation that the Supreme Court cautioned against in Kenya National Commission on Human Rights. The constitutional text of 149(1) is further instructive in its precise choice of language. The provision directs that the National Assembly shall, and in quotes, vote on the nomination. This is a deliberate linguistic choice by the constitutional drafters, and it is not open to a court to substitute its own preferred terminology for that which the Constitution has expressly employed. As the Speaker of the National Assembly correctly ruled, the phrase vote on connotes an electoral determination, so that the National Assembly was in constitutional substance electing the Deputy President from among the nominee presented by the President, and not approving an executive appointee in the manner of a parliamentary vetting process. That interpretation is faithful to the constitutional text and is consistent with the structural design of that provision. This understanding is further reinforced by Articles 1, 2, and 1, 3 of the Constitution, which vest sovereign power in the people and provide for its delegation to, among other organs, Parliament. When the National Assembly votes on a nominee for Deputy President under Article 149(1), it is not acting as a conduit for public opinion, but exercising delegated sovereign authority on behalf of the people. The Constitution makes a deliberate structural choice not to provide for a by-election to fill a mid-term vacancy in the office of the Deputy President, electing instead to vest that determination in the National Assembly as the people's primary representative institution. That choice reflects a conscious constitutional calibration of the respective roles of participatory and representative democracy, a calibration that this court is bound to respect. To accept the petitioner's contention that public participation is a constitutional prerequisite for every decision of constitutional importance would be to obliterate the distinction between participatory and representative democracy, and to impose an obligation on the National Assembly to conduct public participation before every significant vote, including the election of the Speaker, the Deputy Speaker, and appointment of committee chairs. That is plainly not what the Constitution requires. As this court confirmed in Okoiti and 6 others versus Cabinet Secretary for National Treasury and Planning, where it was held that the representative democracy as a complement to participatory democracy is independently and fully constitutionally recognized. The Supreme Court stated as follows, that Article 1(1) declares that the sovereign power belongs to the people of Kenya, and that power can be exercised only in accordance with the Constitution. Article 1(2) further proclaims that the people may exercise their sovereign power either directly or indirectly through their democratically elected representatives. It is this direct democracy aspect the Constitution provides for citizens to participate in referenda on certain constitutional amendments as outlined in Article 255. Additionally, it promotes a participatory approach to governance with Article 10(2)(a) identifying democracy and participation of the people as national values and principles of governance. This is reinforced by specific constitutional obligations such as the duty imposed on Parliament under Article 118 1B to facilitate public participation and involvement in its legislative and other business. Conversely, the Constitution also provides for indirect democracy. In that regard, Article 1(3) states that sovereign power is delegated to specified organs, state organs, including Parliament and the legislative assemblies of county governments. Moreover, Article 94(1) of the Constitution provides that the legislative authority of the Republic is derived from the people and at national level is vested in and exercised by Parliament. This speaks to the representative aspect of democracy, which grants elected representatives the discretion to make legislative decisions on behalf of the people they represent, with the legislative discretion being balanced by the Constitution's commitment to participatory governance. End of quote. While it is unquestionably correct that Articles 110 and 118 of the Constitution apply to all state organs and to all public business, it does not follow that every discrete act of Parliament is intended or is attended by a mandatory public participation obligation. The vote contemplated by Article 149(1) is a discrete, constitutionally prescribed electoral act. It is not the making of a law, it is not the formulation of a policy, it is not the implementation of a public program. It is a binary determination of acceptance or rejection of a single presidential nominee in which there is no middle ground, no policy choice to be made, no legislative text to be drafted, and no program to be designed. Public participation, the purpose of which is to inform deliberative and policy-oriented public decision-making, would add nothing of constitutional value to a binary vote of this character. Furthermore, even were one to extend the concept of public participation to encompass public observation and accountability, we do find that the proceedings of the National Assembly on the nomination of His Excellency Kindiki were conducted in a fully open and transparent manner. The debate was televised, the proceedings were recorded in Hansard, the press was free to report, and members of Parliament were directly accountable to their constituents for the manner in which they exercised their votes. We are therefore satisfied that this openness and transparency, which is the constitutional core of Article 118(1)(a)'s requirement that public conducts its business in an open manner, was amply satisfied. For the foregoing reasons, we hold that public participation was not constitutionally required for the nomination and approval of His Excellency Kindiki as Deputy President under Article 149(1). Next, I will look at the main issue on constitutionality and legality of the standing orders. The petitioners asked this court to consider and pronounce